Okay, so I'm going to be going over the 5 pages and a few additional pages of the listing agreement today. And I won't have, this is cutting it from a 3-hour class into 30 minutes. So I'm going to do the best I can to just cover as much as possible. The first thing I want to go over is the real estate agency. The main thing you need to know about an agency is that this will give you an opportunity to either represent the buyer or the seller or both, a dual agent. And in all regards, you need to have exercise reasonable skill and care and performance of your duties, a duty of honest and fair dealing and good faith, and a duty to disclose all material known facts that materially affect the property. And basically, sellers, they like working with people they trust, someone that they know are going to be representing to the best of their ability. So on this form, I'll be telling you things like where you'll be signing. You'll be signing as seller at the bottom of the form. You'll be using BHHS California Properties, and on all the forms, wherever you relate to the broker firm, you'll be using Bruce Mulhern ID, license ID, which is 00338699. And then below that, you'll be signing as agent, and then putting your license number next to that. If you're working with a co-agent, you also need to have agency representing the seller, and you can just have your co-agent sign next to your name and her license above that, or use a separate agency form. Another agency that we'll be using is possible representation of more than one buyer. Give the seller information in regards to working with multiple buyers, multiple sellers, or having a dual agency. So basically, it's an informative piece for the seller that he should be made aware of, because you are acting not only as a seller for him, but you also have other clients that you're going to be representing as buyer and seller, and he needs to be made aware and disclose that you are basically in the business. Okay? So let's say that you are using an additional agent. You are co-listing with someone. There is a form out there that you can use to disclose to the seller that you are working with another agent representing him, and it's the additional agent acknowledgement. What I like about this, this basically tells the seller that you and your co-agent have entered into a separate written agreement to share the commission. It won't affect the commission that he's agreed to give to you. And it also tells him that wherever the signature of one agent has signed, the other is deemed to have signed. So you don't have to chase each other around getting 2 signatures on all the disclosures that you use. So this is a good form to use to disclose to the seller. And for that matter, once you enter into a transaction, you can use it to show all the parties involved of the agency. And if you want an idea of some kind of agreement, some kind of form that you can use to share with your co-listing agent, they have some in the office. I saw one in the office called Agreement to Share Listing Client, and it basically gives out the terms and how they're going to share. I strongly suggest that you work this out at the beginning. You don't want to get in the middle of the transaction and have one of the agents say, wait a minute, I think I've done a lot more work. I really think it shouldn't be 50-50. I think it should be more like 60-40, and you don't want that to happen. Just agree to it up front and take it from there, okay? So now we're going to the first page of the residential listing agreement. This page basically contains the most of all the terms and everything there are in the listing agreement. So I'm going to go over from top to bottom on this page. Okay, so at the very beginning we have date prepared. If you should modify this contract down the road, this is the date you're going to be using. On the second line, exclusive right to sell, you want to go into realist. I usually call a title company. We use Orange Coast Title, and ask them if they could please send me the latest vesting on the property, so that way I can determine exactly who the title holders are on the property. It could be in a trust, it could be in a corporation, but usually it is, Sam Arnold and Ann Johnson. But bottom line, you want to get all the people that are on title on this top line. The second line, hereby employs and grants Berkshire Hathaway California Properties. That's the broker that you'll be putting on that line. And the next one is the beginning and the ending date. The beginning date would be the date that you put on the MLS. The ending date is the date that your listing will expire. That's the date that the seller will be watching. And of course, we're awesome realtors. We don't have to worry about that. But in the event that date should come close, you will need to use a form called modification of terms to move that date out. And it has to be signed by the seller. You want to get the address right. You want to get the parcel number right. Try to have all this information filled out. The next is listing price and terms. Obviously, you want to get the price at a good spot. So I usually put, interior pictures just in case the buyer thinks it's listed a lot higher. I said, well, Mr. Seller, I know you feel your house is worth the same as the next door, but they also have remodeled their entire kitchen and their bathrooms, and yours is the, we do have programs that we can offer to sellers if they do want to increase the value of their house, called the cosmetic loan program, which I'll go over in a minute. But bottom line, it's a wonderful program that will give sellers money to fix up their house, and then when they sell it, they'll be able to sell it at a higher price. Listing terms. This is something you would use to put in something like 1031 exchange. Maybe they want possession to be 3 days after close. Maybe it's subject to seller finding a replacement property. Things like that you would want to put on here. Or if you want to lower the price down the road and you'd like to address it up front when you take the listing agreement rather than using the modification later, you can just say, in the event we do not have an offer within a certain amount of time, seller agrees to reduce the price, something like that. So the next one is compensation. Just go in with a great presentation, and the more the seller likes you and trusts you, I think you can get at least 6%. That's the goal for me. During the listing period, during the listing period, the broker or cooperating broker procures a ready and able buyer offers on any price and terms is accepted by the seller. So you not only have to bring even the asking price, but you have to get the seller to accept it. He does not have to bring in, he does not have to sign the purchase agreement if the seller may decide, well, I think I want to increase our price or something like that. But your goal is to get that property into escrow. And if within 180 days, I use 6 months only because after the listing period, if that seller were to enter into a contract with someone that saw the property or made an offer on the property during your listing period, you are due a compensation. Even that's within 6 months after your listing has expired. So you want to give a list of names of those potential buyers, and on the day of the expiration or cancellation or extension of the listing, make sure that he has it in hand. So if he does list it with another realtor, he can advise that realtor, if I go into contract with any of these people, I will owe the compensation to my previous realtor. So if the compensation of the seller is prevented by a party other than the seller, then you are due a compensation if the seller collects damages by suit. So basically, you only get 1/2 of that, and that's after they deduct some of the expenses for the cost that was involved in getting the lawsuit through, and if there's any title and escrow expenses that they want to add in. So it's it can go up to 3% of the purchase price, liquidated damages. So seller's been advised policy regarding cooperating with another broker compensation to selling agents. In this case, you could put half of whatever you're getting from the seller, or you could make it a little bit less and you would get the larger portion. It's up to you and how you want to advertise and market your property. Broker is authorized to cooperate with and compensate brokers operating outside the MLS as per broker policy. There might be instances when you will receive an offer and you pull up their license and it turns out he isn't in the MLS, you can just use his broker's number to follow through as far as marking on the MLS who the cooperating broker is. As far as seller represents that seller has not previously entered into a listing agreement with another broker, if he has, he should let you know. And just in case there is a list of names that that agent has given him, you should ask about it. And then that seller should put that list of names on the next section. Seller warrants that has no obligation to pay compensation to any other broker unless the property is transferred to any of the following individuals. And that is the list of names that the previous agent had given him. So those names would go there. If that seller enters into a transaction with any of those people, you are not due a compensation. So, but you aren't obligated to help that seller either. So basically, it goes from there. So items excluded and included. My advice is to go over all the items that come in the purchase agreement. There's some things that the seller will want to keep, maybe that sub-zero refrigerator, maybe that fountain that's in the backyard that the seller feels that he can take. The problem is, in the purchase agreement, that fountain is listed as items included in the purchase agreement, and the purchase agreement supersedes this listing agreement. So it's your job, representing the seller, if there's anything that that seller wants to keep in the house, it's your job to make sure that the seller gets to keep it. So if anything is mentioned or not mentioned but needs to be, counter it back when you get the offers in. Page 2, there's lease items. If there are lease items, you need to, the seller needs to let you know, because those items are included in the buyer's debt to income ratio, and it could possibly kick that buyer out of the purchase if he is, right on the border of being able to qualify for the purchase. So you do need to let the buyer know immediately what the lease terms are. Liened items, those are items like the PACE loan, the HERO loan, that is paid through the city taxes, or paid through the property taxes, and those are a lien on the property. There are some lenders that will allow you to transfer that payment on to the new buyer, but and generally you do have to pay them off. But just check with your lender to see if they qualify, and they can do that based on the loan program they're using. Multiple listing service. We're with the CRMLS, and we are to let the seller know in the event that we are not in the geographical area of our MLS. We need to let him know that, because if you are out of the area, there might be some potential buyers that don't see it because you are not in that, your MLS doesn't cover that area. So I would suggest just using a referral myself. I would use a referral, just get a referral fee, and that way I feel the seller would be best represented by someone that's familiar with the area and has more visible people to view the property. So the next section, what is an MLS and what are the benefits of the MLS? You just need to, I don't have time to go through the whole thing, but obviously to opt out being on the MLS will undermine the seller's ability to have as many people as possible view the property. So I highly encourage the seller to allow us to put it on the MLS. There might be certain instances where maybe the seller wants to do some painting, or he isn't ready really to have it viewed on the MLS. There is a form, an SEL form, that the seller would fill out, and it just states that the seller elects to exclude the property from the MLS as provided, and it gives specific dates at this date, at this length of time, and just give them a little bit of time to get the house fixed up. Okay, so you do have to send that form in to your to the MLS. So technically, you are supposed to put the property in the MLS within 2 days after having the listing agreement signed. So I would make sure, if you do put up a sign, especially agents that see that sign up there for more than 2 days and don't see it on the MLS may call it in and say violation. So you want to try to follow through, or at least keep that form in your file so that if anyone should call you on it, you have the form ready to go. Page 3, It's more information about the MLS. It's talking about the specific information that can be excluded, and it tells the seller all the opt-out features, how it potentially kind of undermine a lot of marketing that could go out there to potential buyers. So he can opt out of certain internet items, but it's really out of your control. Once you put it on the MLS, the other internet sites will be capturing from it, and it's really hard to neither the seller nor the agent can really control some of the information that's out there and who uses it and what use they make of it. Broker and seller duties. Broker is authorized but not required to order reports and disclosure and market the property as necessary. And there is a little note in there to disclose to any real estate agent making an inquiry receipt of any offers on the property. I usually go for the highest mark for the seller. If I have multiple offers above asking, I'll let them know you got to get it above here. If I have offers below, then I say just send in your highest and best. You don't have to be specific on the amounts. It does say but not required. You are authorized but not required. Seller agrees to offer presented by a broker acting in good faith to accomplish the sale of the property. The seller should make the property available to view as best he can. If he's living in the property, maybe make arrangements for an open house, maybe a 2-hour window period or 24-hour notice to view the property, but try to make reasonable arrangements so potential buyers can see the property. That's the best that you can do. So seller agrees to indemnify, hold broker harmless from any claims, disputes, litigation, judgment, attorney fees, and costs arising from any incorrect or incomplete information supplied by the seller. So basically the seller should be completely upfront with you. If there's anything that he is aware of that would affect his ability to sell the property, he needs to let you know. Agency relationship. You need to just have a disclosure regarding agency. That's one of the agencies. You need the possible representation of more than one buyer. And you need to disclose to the seller if you are acting in a dual agency. And that would include offers from any of the offices that are within our Berkshire Hathaway chain under Bruce Mulhern. There are other Berkshire Hathaway offices that are further south. And it does say Berkshire Hathaway Home Services, California Properties, but they're under another broker. In that case, it would not be a dual agency. So if you are aware that it is a dual agency, then you need to let the seller know prior to the seller execution of the purchase agreement. Security and insurance. Broker is not responsible for loss or damage of personal or real property. Photographs and internet advertising. Oh, and broker does not maintain insurance to protect the seller, so the seller should get some kind of insurance, protect all of his valuables. Photographs and internet advertising. Seller agrees to let the broker photograph and electronic capture images of the exterior and interior. Seller acknowledges that once images are placed on the internet, neither broker nor seller can control over who can view such images and use viewers may make of the images. Seller acknowledges that prospective buyers coming into the property may take photographs also. Broker does not have the ability to control or block that taking. Key safe lockbox. Broker, cooperating broker, MLS, brokers and realtor are not insurers against injury, theft, loss, vandalism, or damages attributed to the use of the key safe lockbox. So if you do use a lockbox, try to let your seller know it's very important. All important items need to be securely put away someplace, and we do not insure any loss of any of those items. I strongly suggest it says sign. Seller does authorize broker to put a for sale sold sign up there. You know, during the listing contracts class that we have here on Saturday, I get a chance to talk about things that have happened with me. Other people in the class share what's happened on all these pages, so it would be really wise to actually come to the class so you can get more detailed information. Management approval. Broker or manager has the right to cancel this agreement in writing within 5 days after its execution. So if there's something that the management doesn't approve of in regards to your agreement with the seller, they have 5 days to look at it and determine if they want you to not move forward with this transaction. Dispute resolutions, mediation, seller and broker agree to mediate. So they want you to try to mediate first before moving forward to arbitration. The next level up would be arbitration. The arbitration shall be a retired judge or justice or an attorney with at least 5 years of residential real estate law experience, unless the parties mutually agree to a different arbitrator. I have been to an arbitration, and it's basically in a regular courtroom. It's the seller and the buyer and their agents, and they tell the judge their sides, and then the judge makes a decision. It's pretty simple, but I think it's effective, and I feel the judge performed well. Additional mediation, of course, there's mediation and arbitration doesn't apply to things like foreclosure or unlawful detainers, things that are outside this realm of contract. We're dealing with our real estate, not with all these other guys outside. But the foreclosure and the unlawful detainer and mechanics lien, those are not within the mediation and arbitration items. So in the entire agreement, all prior discussions are superseded by this agreement. All prior discussions, negotiations, agreements between the parties concerning the subject matter of this agreement are superseded. So any verbal agreement, he said, oh sure, I'll give you, 7%, but when you get down to the contract, he only accepts 5 or 6%. This contract will supersede it. Ownership and title. No other person has title to the property. Seller has the authority to both execute this agreement and sell the property. So I usually put none on there just to make sure if someone else pops up down the road, it was something that was not disclosed to me. I want to close the transaction, and I want all the parties involved on title to be there at close. Represented capacity. Sometimes you'll be listing this property with a trust that's under a trust. You'll have a trust advisory attached, and you'll also have a representative capacity form which states that this person is acting as trustee of the trust. If you're selling for an LLC or a corporation, title would need a document showing proof in the end that that person is in fact allowed to sign on behalf of the entity. And it'll be a form that states he would be signing only as a representative and not as in an individual capacity. Okay, so there is an attachment, a seller's advisory. So basically this disclosure goes over the general duties that a seller must have and the statutory duties. And the seller is to deliver to the buyer, among other things, a real estate transfer disclosure statement, a natural hazard disclosure statement. You have legal obligation to honestly and completely fill out the TDS. We'll go over that when I will be going over disclosures in a few minutes, and I'll go over the transfer disclosure statement and all the statutory items that a seller is required to do. And he is required to give those out within 7 days after accepting and opening escrow. So you're also required to give a homeowner's guide to earthquake. So death and other disclosures, you have no obligation to disclose after 3 years if it's 3 years back, but in all fairness to the buyer, if you are aware of a death on the property, I advise that you let them know, because it would be even a traumatic experience if they find out that someone died in the house 4 years ago, So I usually encourage, if you are aware, let them know. Contract terms and legal requirements. A buyer may request as part for the sale of the property that you pay for repairs. So it is up to the seller when he does get a request for a repair, whether he wants to even respond to that request for repair or how many of the repairs he wants to do. But it may make a difference as to whether you're able to move forward based on your answers. So, try to take the request for repair seriously, and if you can work something out, try. On the second page of the seller advisory, it does talk about withholding taxes in regards to non-foreign status, and in California in regards to residency. It talks about prohibition against discrimination, government required repairs. There are certain areas, for instance in LA, that you have to put in retrofit low flow toilets, and they'll even ask for a certification from a contractor stating that he installed those items. There are certain marketing, legal tax and other implications, may have legal tax and insurance title implications, and advise them to consult a professional. Okay, there's marketing considerations, post-sale protections, safety precautions. All these things I really think are important 2 pages that I would encourage the seller to read. Okay, some of the forms that you'll be using in this transaction that are mentioned in the contract: seller's instructions to include the listing from the multiple listing service. This is the form they would use. Representative capacity signature, if they are the seller's representing an entity like a corporation, a trust, or an LLC. Modification of terms, this is the form that you would use if you want to move the expiration date out, or if you want to change the price. If you can address the price within the first day of the listing, that would be great. But if you do change a price, you do have any changes you make to the original terms of the listing agreement will have to be in writing on the modification of terms. The key safe lockbox, sometimes there's tenants that will say no way, no lockbox in my house, but maybe you can work something out with the tenants. Cancellation of listing. In case you do have a seller that wants to cancel, it does have to be signed by your manager or broker, and it's got to be a really good reason. Notice of prospective buyers or transferees. This is the page that you would give to the seller at the end in the event that you do have an expiration. You want to give the seller a list of names of people that saw the property during your listing period or made offers during your listing period. And if he goes into a contract with any of those people, you're due a compensation within the time period that you stated on your listing agreement. Single party compensation, you might go door knocking. Mr. For sale by owner, are you working with realtors in the event they do bring you a buyer? And the seller says, sure, I'll give you 3%. So as a single party compensation. Trust advisory for the listing if it's under a trust. Charges for required homeowners association. If your seller does live in an HOA, there are a list of a civil code section, which all the HOA are aware of. But bottom line, the seller has to pay for these things. It used to be it would come out of the buyer's deposit money, and then they would pay for it. But now the seller, you can still order it through escrow, give escrow the money, and escrow will order it for you. But you do need to pay for the documents up front. And then there's non-statutory homeowner association. Things that I think are important, like parking spaces, pet restrictions, things like that. Other forms you might use is short fill information. There's a few, in case you're doing a short sale. Berkshire Hathaway Home Services, short sale disclosure. 2 more, I'm going to get it through. Hold harmless agreement, that's a Berkshire Hathaway hold harmless. You're going to do the best you can, but no guarantees if you're working with a short sale especially. And the Berkshire Hathaway affiliate business arrangements disclosure. If we do escrow, Castlehead Escrow or Orange Coast Title, there is an affiliation that the broker does have with these 2 entities, and you have to disclose. So I hope that to see you in one of these classes. I know I'm going to redo a lot of the classes they have to offer. And I thank you for listening to this little presentation. I'm sorry it had to be so brief, but like I said, it is a 3-hour class, and it will be much more detailed if you come to the class. And I hope to see you at all of them. It'll really increase your real estate success. I wish you all the best.